Think of the Middle Ages. What comes to mind? Probably mud, plagues, kings with too much power, and peasants with none. Maybe you picture brutal justice, trials by fire and water, torture devices in dark dungeons. It's a common image, and it's not entirely wrong, but it's not the whole story either. Did you know that the origins of trial by jury started in medieval England? Or that some communities forced everyone to chip in to pay a victim's family after a crime? We look back and see a world of superstition and brutality. We see a legal system based on divine intervention and the will of a lord. But what if that system, in its own strange way, contained seeds of fairness we still recognize today? What if some of its principles were more focused on restoring communities than our modern courts are? Their world was different. Their problems were different, so their solutions were different. But were they always unfair? Sometimes the answer is no. Sometimes their ideas about justice were surprisingly practical, humane, and focused on one simple thing: fixing what was broken. Let's look at some of these old laws. They might just make you question what you think you know about justice then and now. Number 18. What if a murderer could just pay a fine? It sounds absurd. Today, murder is the ultimate crime against the state. The person who commits it is prosecuted by the government, and if found guilty, they face a long prison sentence or even death. The victim's family gets justice, but they don't get direct compensation from the killer. Their role is largely that of a witness, but in early medieval Europe, particularly among Germanic tribes like the Anglo-Saxons, the system was completely different. It was called wergild. Wergild, which translates to man price, was a system of structured payments. Every person had a price on their head, not for a bounty hunter, but as a value. If you killed someone, you owed their family their wergild. The idea wasn't primarily about punishment in the way we think of it. It was about restitution. It was about preventing a blood feud. Think about it. In a society without a strong central police force, if a member of your family was killed, your honor and your duty demanded revenge. You would kill a member of the killer's family, then they would retaliate against yours. This could spiral into a multi-generational war that could tear a community apart. Wergild was the circuit breaker. It provided an honorable, accepted alternative to vengeance. The payment acknowledged the wrong, compensated the family for their loss, and restored peace. The laws were incredibly specific. One of the earliest surviving Anglo-Saxon law codes, from King A. Ethelbert of Kent around the year 602, lays out the prices. The wergild for a freeman or a ceorl was much lower than that of a nobleman, a thegn. The king's value was astronomically high, making an attack on him an attack on the entire kingdom. The laws even detailed payments for specific injuries. Losing an eye, a hand, a finger, or even a tooth had a set price called a bot. A front tooth was worth more than a molar. Everything was calculated to prevent disputes. You didn't argue about the severity of the wound, you just looked up the price in the lockup. Of course, this system feels deeply unfair to our modern sensibilities. It explicitly states that a nobleman's life is worth more than a peasant's. It puts a price on human life, which feels morally wrong, and it allowed the rich to literally get away with murder, as long as they could afford the payment. The Norman conquest of England in 1066 began to change this. William the Conqueror and his successors wanted to centralize power. They introduced the concept of the king's peace. A crime was no longer just a wrong done to a family, it was a breach of the king's peace. Therefore, the fine, now called an amercement, was paid not to the victim's family, but to the king. The state became the injured party. This was a fundamental shift. Justice became public and punitive, rather than private and restorative. But was the old system entirely without merit? The legal historian Frederick William Maitland, in his work with Frederick Pollock, The History of English Law Before the Time of Edward I, explored how this system was perfectly suited for its time. It was a practical solution for a society based on kinship and local community. It focused on the victim. The money went directly to the family, who had lost a provider, a protector, a loved one. Today, a victim's family might get some funds from a state compensation board, but the offender's debt is paid to the state through prison time. Wergild made the debt personal and direct. It forced the offender and their family to make things right with the people they had directly harmed. It was a form of restorative justice, a concept that modern legal systems are only now beginning to explore again. What we still don't know is profound. If our current justice system focused more on direct restitution from offender to victim, would it lead to a greater sense of closure for those harmed? By making crime an offense against an abstract state, have we accidentally removed the victim from the center of the justice equation? And could we ever create a system of financial restitution today without it simply becoming a way for the wealthy to buy their way out of consequences, repeating the great flaw of wergild? Number 17, what if catching a criminal was everyone's job? Imagine you hear a shot outside your home. Someone has just been robbed. You look out the window and see a person running down the street. In our world, your next move is probably to call the police. You are a witness. It's the police's job to catch the criminal. But in medieval England, the law demanded more. It demanded you join the chase. This was the hue and cry. The hue and cry was a legal duty. If you witnessed a crime or heard the call, you had to stop what you were doing and pursue the suspect. The cry was the alarm, and the hue was the sound of the chase, the shouting and noise made by the pursuers. It was a form of mass deputization, the entire community transformed into a temporary police force. To fail to join the hue and cry was a crime in itself. You could be fined for ignoring your duty. The idea was codified in English law, for instance, in the Statute of Winchester in 1285. This statute formalized the system, making it a cornerstone of local law enforcement for centuries. This wasn't just about catching a suspect, it was about community responsibility. Law and order were not abstract concepts handled by a professional class. They were the shared, active responsibility of every able-bodied person. The system relied on the fact that communities were small and people knew each other. A stranger running through a village would stand out immediately. The chase would spread from village to village, with each community taking up the pursuit as the suspect crossed into their territory. The ultimate goal was to keep the suspect running until they were exhausted and cornered. How was this fair? It created a powerful deterrent. A potential thief or assailant knew that if they were caught, it wouldn't be a single constable they had to outrun. It would be the entire village. It democratized law enforcement. Justice wasn't something handed down from on high by a distant lord. It was enacted by the people themselves in real time. It reinforced community bonds. Working together to catch a wrongdoer strengthened the social fabric. It sent a clear message: a crime against one of us is a crime against all of us, and we will all act to right it. Of course, the system had flaws. It could lead to mob justice. A person could be wrongfully accused, and the heat of the chase might not leave much room for careful consideration of evidence. It was only as effective as the community's willingness to participate. As towns grew larger and society became more anonymous, the hue and cry became less practical. The rise of professional police forces, like the Metropolitan Police in London, founded by Sir Robert Peel in 1829, eventually made it obsolete. The state took over the job of catching criminals, but the principle behind it raises interesting questions. Legal scholar John H. Langbein has written about the shift from community-based justice to state-dominated justice. He notes that while professionalization brought benefits, something was lost. The hue and cry was a system of incredible efficiency for its time, operating without the need for a large, expensive bureaucracy. It was immediate. There was no calling a dispatcher and waiting for a car to arrive. The response was instantaneous. It embodied the idea that public safety is a public concern. We see faint echoes of this today in neighborhood watch programs or the Amber Alert system, which enlists the public's help in finding abducted children. These are modern technological versions of the hue and cry. This leads to some uncomfortable questions about our own time. In an age of urban anonymity, have we outsourced our own safety so completely that we've lost our sense of collective responsibility? What would happen if we were legally obligated to intervene, not just witness, when we saw a crime in progress? And does our reliance on a professional police force make our community safer, or does it simply make the rest of us more passive and less connected to the peace and security of our own neighborhoods? Number 16, could you get a lighter sentence just by reading a single verse? The scene is a courtroom in medieval England. A man has been found guilty of a serious crime, perhaps theft or even manslaughter. The penalty is death by hanging. The judge asks if he has anything to say. The man claims benefit of clergy. A church official hands him a Bible, opened to a specific passage. The prisoner begins to read aloud. If he can read even a single verse, his case is transferred from the royal court to a much more lenient church court. He will be spared the gallows. His life is saved because he can read. This was the benefit of clergy, one of the most peculiar and long-lasting principles in English law. It began in the 12th century during the power struggle between the crown and the Catholic Church. The Church argued that it should have jurisdiction over its own people, the clergymen or clerics. King Henry II famously clashed with his Archbishop of Canterbury, Thomas Becket, over this very issue. Becket insisted that clerics, even those who committed serious crimes, should be tried in ecclesiastical courts, which could not impose death sentences. The conflict ultimately led to Becket's murder in 1170, but the principle he fought for survived and expanded. Initially, you had to be an actual ordained priest or monk to claim the benefit. But over time, the definition of cleric broadened. Courts began to assume that if you could read, you must have some church education, and therefore you were a cleric. The test became a test of literacy. The standard passage chosen was the first verse of Psalm 51, Miserere me, Deus, or have mercy on me, O God. This became known as the neck verse, because reading it could save your neck from the hangman's noose. How on earth could this be considered fair? In a world where justice was often swift and brutal, benefit of clergy acted as a crucial escape valve. It introduced mercy into a harsh system. The death penalty was the prescribed punishment for a huge number of felonies. This principle allowed judges a way to avoid imposing it on first-time offenders or in cases where the punishment seemed excessive. It was a form of mitigation. It recognized that not every crime, even a serious one, warranted the ultimate penalty. Furthermore, it inadvertently valued education. In a largely illiterate society, the ability to read was a rare and valuable skill. Sparing the lives of the literate, even if they were criminals, meant preserving a resource that the community needed. Over the centuries, the rules evolved. At first, it was a get-out-of-jail-free card. Later, to prevent abuse, punishments were introduced in the church courts, such as branding the thumb of the offender. This way, they couldn't claim the benefit a second time for a major crime. Women were eventually allowed to claim it as well. The practice persisted in some form in England for nearly 700 years, finally being abolished in 1827. The historian J.H. Baker, in his An Introduction to English Legal History, details how benefit of clergy functioned as a clumsy but effective tool for sentencing discretion. In a system with rigid mandatory punishments, it was one of the only ways to tailor the outcome to the specific circumstances of the crime and the offender. It was an odd, roundabout way of saying that not all criminals are the same and that justice should sometimes be tempered with mercy. But it leaves us with some troubling thoughts. Was this system really about mercy, or was it a stark example of class privilege, where the educated elite were held to a different standard than the illiterate masses? If a person's life could be spared based on a skill rather than the nature of their crime, what does that say about the very concept of equal justice under the law? And in our modern system, have we just replaced the literacy test with a wealth test, where the quality of one's legal defense and therefore the outcome of a trial often depends on how much money one has? Number 15, could you escape the law just by running into a church? A man commits a crime, maybe it's a theft or a fight that ended in death. The hue and cry is raised and the whole village is after him. He knows that if he's caught, he'll be taken to the local court and likely hanged. But he sees a way out. He sprints towards the local church. If he can reach the door and get inside before he's captured, he is safe. He has claimed the right of sanctuary. The concept of sanctuary is ancient, but in medieval Europe, it became a formalized legal principle. Certain places, primarily churches and monasteries, were considered consecrated ground. The law of the king did not apply there. Once inside, a fugitive was protected from arrest. They could not be forcibly removed. This wasn't a permanent solution. The fugitive had a choice to make. They had 40 days to either surrender to the authorities for trial or agree to abjure the realm. Abjuration was a formal process. The fugitive would confess their crime to the coroner. Then, dressed as a pilgrim and carrying a wooden cross, they would be escorted to the nearest port. They would have to take the first available ship out of England and swear an oath never to return. If they ever came back, they could be killed on sight. In effect, sanctuary offered a choice: face trial and likely execution, or choose exile for life. On the surface, this seems like a bizarre loophole that allowed criminals to escape justice. But its fairness lay in its function as a safety mechanism. First, it prevented summary justice and lynch mobs. The 40-day period acted as a cooling-off period. The heat of the moment would pass. It ensured that a person, even a confessed criminal, would not be killed without some form of due process, even if that process was exile. It was a check on the power of local lords and the immediacy of mob vengeance. Second, it was a form of mercy. For non-capital crimes, it offered a chance for negotiation and settlement. For capital crimes, it offered an alternative to death. Exile was a terrible punishment in the medieval world. To be cut off from your family, your community, and your livelihood was a kind of social death. But it was still life. As the legal scholar William Holdsworth noted, sanctuary provided a necessary element of flexibility in a legal system that was otherwise rigid and severe. The right was widely recognized. Famous sanctuaries like Westminster Abbey in London housed fugitives for centuries. The system was detailed and regulated. The fugitive had to stay within the confines of the church grounds. The community was often responsible for guarding the church to make sure they didn't escape. The process was a public and formal affair, not a secret escape. It was part of the legal landscape. However, the right of sanctuary was also controversial. Kings often felt it undermined their authority. In Henry VIII, severely curtailed sanctuary rights during the Reformation in the 1530s, as part of his broader effort to break the power of the church. By 1623, the general right of sanctuary for criminals was abolished in England by an act of Parliament. The idea that some places are beyond the reach of the law was seen as incompatible with a modern centralized state. The legacy of this idea, however, is powerful. It raises fundamental questions about the limits of state power. Should there be places or circumstances where the law cannot reach? We see a faint echo of this in the concept of diplomatic immunity or in the modern debate about churches offering sanctuary to undocumented immigrants. Is the purpose of justice always to punish, or is there a role for structured, formalized mercy? Did the abolition of sanctuary make the legal system more just, or did it simply remove one of the few options available to a person facing a system with few second chances? And could our own society benefit from a cooling off period between accusation and punishment? Number 14. What if you were legally responsible for your neighbor's crimes? Imagine living in a small village. One of your neighbors gets into a fight and injures someone from a nearby town. The authorities come to investigate. But instead of just focusing on the man who threw the punch, they hold your entire neighborhood responsible. And you, along with 9 of your neighbors, are legally on the hook. If the guilty man runs away, you all have to pay the fine. This was the system of franklage. Franklage was a unique feature of English law that developed after the Norman conquest in the 11th century. The Normans were a ruling minority trying to control a large and sometimes hostile Anglo-Saxon population. They needed a way to maintain order at the local level. Franklage was their solution. The population was divided into groups of about 10 households called tithings. Every man over the age of 12 was required to be in a tithing. The members of the tithing were then sworn to uphold the law and were held mutually responsible for each other's conduct. If one member of the tithing committed a crime, the other members were obligated to bring him to court. If they failed to do so, if he ran away, for example, the entire tithing was fined. This system was overseen by the local sheriff, who would conduct a view of franklage at the local court, usually twice a year, to ensure everyone was properly enrolled and the system was working. This was a core element of local government, as detailed in legal texts like the one attributed to Henry I, the Leges Henrici Primi. How could a system that punishes you for something your neighbor did be fair? Its fairness was rooted in the idea of collective security and proactive policing. It gave every single person a powerful incentive to keep an eye on their neighbors. It wasn't just about minding your own business. Your neighbor's business was your business because their misdeeds could cost you money. This created a powerful social pressure to maintain the peace. It encouraged communities to resolve disputes internally before they escalated into crimes that would involve the authorities. Your franklage essentially made every tithing a small, self-policing unit. It was a brilliant and efficient way to maintain order without a standing army or a large police force. The historian W.A. Morris, in his book The Franklage System, described it as a vast system of compulsory collective bail. Everyone was bailed to their neighbors. It promoted a deep sense of community interdependence. Your well-being was directly tied to the good behavior of the people living around you. This wasn't about abstract civic duty, it was about concrete financial self-interest. The system encouraged people to choose their neighbors wisely and to intervene if they saw someone heading down a bad path. The system was not without its problems. It could be oppressive, it placed a heavy burden on the community, and could lead to neighbors spying on each other out of fear of being fined. It was also a tool of control for the Norman kings, a way to ensure the compliance of their new subjects. As society changed and as towns grew and people became more mobile, the system of franklage slowly faded away. It was largely gone by the end of the Middle Ages, replaced by other forms of local governance like the parish constable. But the core idea of shared responsibility lingers. It forces us to ask some difficult questions. Have our modern societies, with their emphasis on individual rights and privacy, lost the sense of collective responsibility that franklage enforced? We expect the police to keep us safe, but we often feel little personal obligation for the conduct of our neighbors. Would our communities be safer if we had a more direct, tangible stake in the behavior of those around us? And is it possible to foster that sense of shared fate without resorting to the coercive top-down control that was the dark side of the Frank Pledge system? Number 13, could you prove your innocence by getting enough friends to vouch for you? You stand accused of a crime. There is no physical evidence, no surveillance cameras, no DNA. It's one person's word against yours. The plaintiff has sworn an oath before the court that you are guilty. How do you defend yourself? In the early medieval period, one of the most common ways was through compurgation or oath helping. The process was simple in theory. You, the defendant, would swear an oath of your innocence. But your oath alone was not enough. You had to produce a certain number of oath helpers or compurgators who would swear that they believed your oath was true. These were not witnesses to the crime. They did not need to know whether you were actually innocent or guilty. They were character witnesses. Their oath was about your credibility. They were swearing that you were an honorable person, a trustworthy member of the community, and that your oath was clean and unperjured. The number of oath helpers required depended on the seriousness of the crime and your social status. A minor offense might require only a few, while a major one could require a dozen or more. A nobleman might need fewer compurgators than a commoner, as his word was considered more valuable. If you successfully gathered the required number of people, and they all swore the oath perfectly without stumbling over the words, you were declared innocent. The case was over. If you failed to find enough oath helpers, or if one of them messed up the oath, you were found guilty. This sounds like a popularity contest, not a legal proceeding. How could it be fair? Its fairness came from its deep integration with the community. In a small, close-knit society where everyone knew everyone else's reputation, character was a form of evidence. A person's standing in the community, their history of honesty and good conduct, was considered a reliable indicator of their truthfulness. The legal historian R.C. Van Caneghem argued that in a world without modern forensic science, reputation was one of the best tools available for determining guilt or innocence. Compurgation was a trial by public opinion, but a structured and formalized one. It tested your social credit. If you were a known troublemaker, a liar, or an untrustworthy person, you would struggle to find neighbors willing to risk their own souls by swearing a false oath on your behalf. Perjury was considered a mortal sin, a terrifying prospect for the medieval mind. Therefore, the willingness of your peers to stand with you was a powerful testament to your innocence. The system essentially asked the community, is this person the sort of person who would do this thing and then lie about it? It placed the judgment in the hands of those who knew the accused best. The system was most common in Anglo-Saxon and Germanic law, but was also used in church courts for centuries. It began to fall out of favor as other forms of trial, particularly trial by jury, became more common. The Norman kings preferred trials that generated revenue for the crown, and compurgation did not. By the late Middle Ages, it was largely obsolete in royal courts, though it lingered in some local and church courts. Its final, formal abolition in English law didn't happen until 1833, a testament to its long history. But the ghost of compurgation haunts our modern legal system. We still use character witnesses. We still ask juries to make judgments about the credibility of a defendant or a witness. A person's reputation, while not a formal defense, can heavily influence the outcome of a trial. And this raises questions. Does a person's general reputation truly have any bearing on their actions in a specific situation? How much should our past define our present guilt or innocence? And in our fragmented digital world where reputations can be built or destroyed online in an instant, what would a modern system of oath helping even look like? Number 12. Did 12 ordinary people really have the power to defy a king? The modern jury is a cornerstone of the legal systems in many countries. The idea that a person should be judged by a group of their peers feels like a fundamental right. We often associate this with modern democracy, but the origins of the jury are firmly medieval. It did not spring into existence fully formed. It evolved slowly, and its early purpose was quite different from its role today. The story of the jury in England is closely tied to King Henry II, who reigned from 1154 to 1189. Henry was a powerful and ambitious ruler who wanted to strengthen royal authority and create a more uniform legal system. Before his reforms, disputes, particularly over land, were often settled by trial by combat or by ordeal. Henry introduced a new option, a royal writ that allowed a litigant to have their case heard by a group of local men. This group, called an assize, was made up of 12 lawful men from the neighborhood who were sworn to tell the truth. This oath is the origin of the word jury, from the French word juror, to swear. Initially, these were not juries in the modern sense. They weren't impartial observers who listened to evidence. They were more like witnesses. They were chosen because they were local and were presumed to already know the facts of the case. They were asked to declare, based on their own knowledge, who had the better right to a piece of land, for example. The Assize of Clarendon in 1166 extended this idea to criminal law. It established a presenting jury, a group of 12 men in each district who were required to report or present any person they suspected of a serious crime. This is the ancestor of the modern grand jury. The transition to the petit jury or trial jury that we know today happened after 1215. In that year, the Fourth Lateran Council of the Catholic Church forbade clergy from participating in trials by ordeal. This created a crisis in the English legal system. Ordeals, like throwing a suspect into water to see if they floated or sank, were seen as a way of asking God for a judgment. With the church's withdrawal, the courts needed a new way to determine guilt or innocence. They turned to the jury slowly over the next century. The role of the jury shifted. Instead of being witnesses themselves, they became deciders of fact, listening to evidence presented by others. How was this system fair? It was a revolutionary step towards justice based on evidence and reason rather than superstition or brute force. It took the judgment out of the hands of a single powerful judge or lord and placed it in the hands of the community. As the legal historian Sir Patrick Devlin wrote in his book, Trial by Jury, it introduced a little parliament into the courtroom. The jury represented the common sense of the community. It provided a check on the power of the state. A jury could refuse to convict, even if the evidence seemed strong, a practice that would later become known as jury nullification. The principle that a person should be judged by their peers, by ordinary people, was a radical one. It meant that the law was not just the tool of the king and his officials, it had to be filtered through the conscience of the community. This was famously enshrined in the Magna Carta of 1215, which declared that no freeman could be punished except by the lawful judgment of his peers or by the law of the land. While this originally applied only to a narrow class of people, the principle was powerful and enduring. This evolution leaves us with critical questions. What is the true role of a jury? Is it simply to apply the law as a judge explains it, or does it have a higher duty to see that justice is done, even if that means ignoring the law? As legal cases become more complex and technical, are 12 ordinary people still the best way to determine the truth? And in an era of deep political and social polarization, can we still find a truly impartial jury of one's peers? Number 11. Did medieval women really have no control over their money? The popular image of a medieval woman, particularly a noblewoman, is one of powerlessness. She is seen as property passed from her father to her husband with no legal identity or control over her own affairs. This is largely based on the legal concept of coverture, which became dominant in English common law. Under coverture, a married woman's legal existence was merged with that of her husband. She was a femme covert, a covered woman. She could not own property, sign contracts, or sue in her own name. But this picture, while influential, is incomplete. There were important legal principles that gave women, particularly widows, a surprising degree of economic security and autonomy. The most important of these was the dower, right? Dower was the portion of her husband's property that a wife was legally entitled to receive for her support after his death. This wasn't a gift or an inheritance that could be taken away. It was a right. The most common form was a life interest in 1/3 of all the land her husband owned at any point during their marriage. This was a powerful protection. It meant that a husband could not sell or mortgage his land without his wife's consent, because doing so would diminish her future dower, her right attached to the land itself. The process was public and formal. Often at the church door immediately following the wedding ceremony, the groom would publicly endow his bride with her dower. This public declaration ensured that the community knew about her rights. The Magna Carta of 1215 contains specific clauses protecting a widow's dower rights, showing how fundamental this principle was. Clause 7 states that a widow should receive her dower without difficulty and without paying anything for it. Clause 8 states that no widow should be forced to remarry against her will. These provisions gave widows a significant measure of independence. How was this fair? In a society where land was the primary source of wealth and power, and where women had limited opportunities for earning a living, dower provided a crucial social safety net. It ensured that a widow would not be left destitute and dependent on the charity of her children or her late husband's relatives. It gave her a home and an income for the rest of her life. As a widow, a feme sole, she was legally independent. She could manage her dower lands, sign contracts, and appear in court on her own behalf. For many women, widowhood was the first time in their lives they experienced true legal and economic autonomy. Research by historians like Barbara Hanawalt, who studied medieval peasant life, shows that these rights were not just for the nobility. Peasant women also had customary rights to dower, which were recognized in the manorial courts that governed their villages. While coverture was a real and restrictive legal doctrine, dower acted as a powerful counterbalance. It recognized that a wife's contribution to a marriage, while not economic in a direct sense, created a right to a share of its assets. Of course, the system was far from perfect equality. A woman's dower right was still dependent on her husband. She only gained control after his death. And while she had a life interest, she could not sell the dower lands or pass them on to her own heirs after her death. They reverted to her husband's heirs. Nevertheless, compared to the narrative of complete female subjugation, the right of dower reveals a more complex and nuanced reality. This forgotten principle raises some interesting questions for our time. In modern divorce law, we debate how to divide marital assets, often trying to quantify each partner's contribution. Did the simple fixed rule of dower provide a clearer and perhaps more stable form of economic protection for women? By linking a woman's economic security directly to her husband's property, did the law reinforce dependency, or did it realistically acknowledge the economic realities of the time? And as we move towards more equal partnerships, have we lost the idea that marriage itself creates a fundamental right to security that should be protected by law regardless of who earned what? Number 10. Who decided what was fair on the open sea? The law of the land is one thing, but what happens when you're on a ship in the middle of the ocean? Who is in charge? What are the rules? In the Middle Ages, as maritime trade grew, a unique and highly practical body of law emerged to answer these questions. It wasn't dictated by a king or a parliament. It was created by the merchants and sailors themselves. This was the law of the sea, and one of its most important expressions was the laws of Oleron. The laws of Oleron are a collection of judgments and customs related to maritime affairs. Their exact origin is debated, but they are traditionally associated with the island of Oleron off the Atlantic coast of France, and are believed to have been compiled in the 12th century, possibly with the encouragement of the formidable Eleanor of Aquitaine. Radical-Heen believes these laws were not a theoretical legal code, they were a practical handbook for resolving the everyday disputes that arose at sea and arose at sea. They were written in a simple, direct style, meant to be understood by the people who would use them. The laws covered everything. They detailed the duties of the ship's master and the rights of the seaman. They set out rules for hiring and paying the crew. They had provisions for what to do if a sailor fell sick. For example, one article stated that a sick sailor should be put ashore and cared for at the ship's expense, with a ship's boy left to look after him. They established rules for cargo. What happens if, during a storm, some of the cargo has to be thrown overboard to save the ship? This is called jettison. The laws of Oleron established the principle of general average, which meant that the owners of the cargo that was saved had to compensate the owner of the cargo that was lost. The loss was shared by everyone who benefited from the sacrifice, what made this system so fair. First, it was created by the people it governed. It was a bottom-up system of law based on the accumulated wisdom and experience of seafarers. It reflected the realities of their world. As the legal scholar William McFee noted, the law of the sea has always been more pragmatic and less formal than the law of the land. It prioritized what worked. Second, it was surprisingly balanced. While the master of the ship had great authority, he also had clear responsibilities. He had to consult with his crew before making important decisions like whether to set sail in bad weather. If he sold the ship's cargo in a foreign port, the crew was entitled to their share of the freight charges for the return journey, even if they didn't have to carry any cargo. The laws of Oleron became the foundation of admiralty law throughout Europe. They were copied and adapted in England, Spain, and the trading cities of the Hanseatic League. Their influence is still felt today in modern maritime law. The principle of general average still exists. The idea that sailors are entitled to maintenance and cure if they fall ill in the service of the ship is a direct descendant of these medieval rules. This practical, self-governing legal system prompts us to think about how laws are made. Do the best rules come from legislatures and judges, or from the communities that have to live with them? The laws of Oleron suggest that specialized communities are often best equipped to regulate themselves. Could other industries or professions benefit from a similar system of peer-generated, practical rules instead of top-down government regulation? And in a globalized world, is there a lesson to be learned from a legal code that was so successful it was voluntarily adopted across national borders, creating a single, predictable set of rules for an entire industry? Number 9, what happens when the law is legal but not fair? The common law of medieval England was a powerful and rigid system. It operated on a system of rights. To bring a case, you had to find the right writ, the right piece of paper that fit your specific problem. If your problem didn't fit into one of the existing boxes, you were out of luck. The law courts could be inflexible. They were concerned with rules and procedures. Sometimes this led to outcomes that were legally correct but morally unjust. So where did people go when the law failed them? They went to the king. The king was seen as the ultimate fountain of justice. People who felt they had been wronged by the common law courts could petition the king directly for a remedy. The king, being a busy man, delegated this task to his chief minister, the chancellor. The chancellor was usually a high-ranking clergyman, often called the keeper of the king's conscience. He would hear these petitions in his own court, the court of chancery. This court did not operate according to the strict rules of the common law. Instead, it operated on the basis of equity or conscience. The goal of the court of chancery was not to apply the letter of the law, but to achieve a just and fair result. It developed its own set of principles and remedies. For example, the common law courts could usually only award monetary damages. If someone broke a contract to sell you a unique piece of land, the law court could make them pay you damages, but it couldn't force them to actually hand over the land. The court of chancery, however, could issue an order of specific performance, compelling the person to fulfill their promise. It could also issue injunctions, ordering a person to stop doing something harmful. One of the most important creations of the Court of Chancery was the use, which was the forerunner of the modern trust. Under the common law, it was difficult to leave land to anyone other than your direct heir. The use allowed a landowner to transfer his land to a trusted friend, to the use of his wife or younger children. The common law courts wouldn't recognize this arrangement. They only saw the friend as the legal owner. But the Court of Chancery would enforce the use. It would compel the friend to honor his moral obligation and use the land for the benefit of the family. This was a revolutionary legal tool. How was this system of equity fair? It provided a vital corrective to the harshness and rigidity of the common law. It was a court of conscience. As the legal maxim went, equity follows the law, but it would intervene to prevent a manifest injustice. It recognized that sometimes following the rules leads to the wrong answer. As the great legal historian F.W. Maitland said, equity came not to destroy the law, but to fulfill it. It softened the sharp edges of the law and introduced a degree of flexibility and moral consideration that was otherwise lacking. The existence of a separate system of equity created a tension in English law that lasted for centuries. The common law judges and the chancellors often clashed, but the system endured, and the principles of equity became an integral part of Anglo-American law. In the 19th century, the separate courts were merged, but the distinction between legal remedies and equitable remedies remains crucial to this day. When a court issues a restraining order, it is using a power derived from the medieval court of chancery. This dual system of law and equity leaves us with fundamental questions about the nature of justice. Should our legal system be based on firm, predictable rules or on flexible principles of fairness? If we allow judges too much discretion to do what they think is fair, do we risk creating a system that is arbitrary and unpredictable? On the other hand, if our laws are too rigid, do we create a system that is blind to injustice? The medieval solution was to have two systems working side by side. Have we found a better answer? Number 8, how did a simple piece of paper guarantee your day in court? Imagine you're a medieval farmer and your neighbor has seized a piece of your land. In an early chaotic system, your only recourse might be to gather your relatives and fight to get it back. But by the 12th century in England, you had a new option. You could go to the king's officials and buy a piece of paper. This paper, a royal right, was a short, formal letter from the king, commanding your neighbor to either give back the land or appear in a royal court to explain why he should not. This simple document was the key that unlocked the door to the king's justice. The writ system was another of the great legal innovations of King Henry II. His goal was to make royal justice accessible, predictable, and superior to the justice offered by local lords in their own feudal courts. Before Henry, royal justice was exceptional. After Henry, it became routine. The writ was the mechanism that made this possible. Each type of legal problem had its own specific writ. There was a writ of novel disseisin, recent dispossession for someone who had just been thrown off their land. There was a writ of debt for someone trying to collect a loan. There was a writ of trespass for someone who had suffered a direct physical harm. To start a lawsuit, you had to choose the correct writ for your situation. This was known as the formulary system. If you chose the wrong writ, your case would be thrown out and you would have to start over. This seems incredibly rigid, and it was, but it also had a profound element of fairness. The writ system made the law predictable. The procedures for each writ were fixed and known. It meant that justice was not based on the whim of a local lord or the unpredictable outcome of a trial by combat. It was based on established rules. The rights were also a powerful tool for centralization. They drew legal business away from the feudal courts and into the king's courts. This created a single common law for the entire Kingdom of England. The decisions of the royal judges were recorded and used as precedents, creating a consistent and developing body of law. As described by the 13th century legal scholar Henry de Bracton in his treatise on the laws and customs of England, the writ system was the engine driving the creation of the English common law. Most importantly, the writ provided access to justice. For the price of the writ, an ordinary freeman could bring the power of the king to bear on his local dispute. He could force his more powerful neighbor to answer to the law. The writ was a statement that no one was above the law and that the king's courts were open to all his subjects. It was a tangible symbol of the rule of law. It transformed justice from a private affair into a public one, guaranteed by the central government. The system's rigidity eventually became its weakness. As society became more complex, new types of problems arose that didn't fit into the existing rights. The courts were reluctant to create new ones, leading to the inflexibility that made the Court of Chancery and its system of equity necessary. In the 19th century, the old formulary system was finally abolished, and a lawsuit could be started with a simple statement of claim. But the legacy of the right system is immense. It established the principle that access to justice should be a matter of right, not of favor. It created a system of law that was, in theory, the same for everyone. It forces us to ask about our own system. Have we made access to justice too complex and expensive? A medieval farmer could buy a writ for a few shillings. Today, starting a lawsuit can cost thousands of dollars in legal fees. Has our modern, more flexible system accidentally created higher barriers to entry than the rigid but accessible system of medieval rights? And what is the modern equivalent of a royal writ, a simple, affordable key that can unlock the doors of the courthouse for an ordinary person? Number 7, can you be guilty of a crime you didn't mean to commit? A woodcutter is chopping a tree near a road. He calls out a warning. His axe head flies off the handle and strikes a person walking by, killing them. Is the woodcutter a murderer? Today we would immediately ask about his state of mind. Did he intend to kill the person? Was he acting recklessly? Was it just a tragic accident? This focus on the mental element of a crime, what lawyers call mens rea, or the guilty mind, seems obvious to us. But in early medieval law, the focus was often just on the act itself, the actus reus. If your act caused the harm, you were responsible. Early Germanic and Anglo-Saxon law was primarily concerned with causation. Did you do the thing that led to the death or injury? If so, you owed the wergild. The law, as seen in codes like the Leges Centrici Primi, made little distinction between an intentional killing and an accidental one. The outcome was the same, a person was dead, and the social balance had to be restored through payment. This seems profoundly unfair. How can you be blamed for a pure accident? However, during the course of the Middle Ages, a crucial shift occurred, largely under the influence of the Church and its canon lawyers. The Church was concerned with sin and moral culpability. For the Church, intention was everything. For God judges the state of a person's soul, not just their actions. This thinking began to seep into the secular common law. There were thinkers like Peter Lombard in the 12th century, and later Thomas Aquinas argued that a morally blameworthy act required a wrongful intention. By the 13th century, this idea was becoming established in English law. The legal scholar Henry de Bracton wrote that a crime is not committed unless there is an intention to injure. The courts began to develop ways to distinguish between different levels of culpability. They started to look at the difference between a killing that was by misadventure, an accident, one that was in self-defense, one that was in the heat of passion, manslaughter, and one that was done with malice aforethought, murder. How was this development fair? It was a monumental step forward in the concept of justice. It aligned the law with a basic human intuition. We should only be punished for the wrongs we choose to commit. Is the intention the guilty mind? That makes an act a crime. Punishing someone for a pure accident is not justice, it is just assigning blame for a tragedy. The development of mens rea meant that the law was no longer just a blunt instrument for keeping the peace. It was becoming a more sophisticated tool for assessing moral responsibility. This principle allowed for the development of defenses and mitigating circumstances. A person who killed in self-defense was not a murderer. A person who killed accidentally while doing a lawful act, like our woodcutter, was not a murderer. The law began to tailor the punishment to the degree of the offender's blameworthiness. This was a profound humanization of the criminal law. The focus shifted from the harm caused to the moral choice made by the actor. The full development of the complex doctrines of mens rea took centuries, but its roots are firmly medieval. The transition from a system based on pure causation to one based on intent is one of the most important and fairest developments in the history of Western law. But it also leaves us with some of the most difficult questions in law. How can we ever truly know what was in another person's mind? We have to infer their intent from their actions and words, a process that is always uncertain. Where do we draw the line between recklessness, which is criminal, and mere carelessness, which is not? And have we gone too far in some areas, creating strict liability offenses where a person can be found guilty even if they had no intention of breaking the law, in a strange echo of the early medieval system that focused only on the act itself? Number 6 was medieval punishment always just cruel and unusual. When we think of medieval punishment, we often picture the stocks, the gibbet, and the executioner's axe. We think of punishments that were public, painful, and often fatal. The penalties for crime were undeniably harsh by our standards. The death penalty was common for a wide range of felonies, but to dismiss the entire system as mindlessly brutal is to miss a subtle but important principle that was at work, the idea of proportionality. Medieval justice, in its own way, strove to make the punishment fit the crime. This wasn't always about mercy. Sometimes it was about making the punishment reflect the nature of the offense in a symbolic or literal way. This is often referred to as mirroring punishment, or lex talionis, the law of retaliation, the principle of an eye for an eye. While this sounds brutal, it is also a principle of limitation. It means an eye for an eye, not a life for an eye. The punishment should not exceed the harm done. We can see this principle at work in many specific punishments. For example, a baker who sold a loaf of bread that was underweight might be drawn through the streets on a hurdle with the light loaf tied around his neck. This was a public shaming that directly related to his crime. A brewer who sold bad ale might be forced to drink a large quantity of it and have the rest poured over his head. A forger who created false coins could have his hand cut off, the hand that committed the crime. These punishments were certainly harsh, but they were not random. They were meant to be understood by the community as a direct and fitting consequence of the specific offense. Even in capital punishment, there were gradations. A common thief might be hanged. But a traitor, who had committed the ultimate crime against the community and the king, faced the gruesome punishment of being hanged, drawn, and quartered. The severity and symbolism of the punishment were scaled to match the perceived severity of the crime. Similarly, fines and amercements were often scaled based on a person's wealth and status. A rich man would pay a larger fine than a poor man for the same offense, a principle laid out in the Magna Carta. The goal was for the punishment to have a similar bite for everyone. How is this fair? It established the principle that justice is not a one-size-fits-all system. The consequences of a crime should be related to the act itself. This is a fundamental principle of fairness that we still believe in today. Our modern sentencing guidelines, which set out different ranges of punishment for different crimes based on their severity, are a direct descendant of this medieval idea. The principle of proportionality is a core protection against excessive and arbitrary punishment. It is enshrined in the Eighth Amendment to the U.S. Constitution, which prohibits cruel and unusual punishments. The legal historian Sir James Fitzjames Stephen noted that while medieval punishments were severe, they often reflected a society that took concepts like honor, community, and treason far more seriously than we do today. The public and symbolic nature of the punishments was a form of mass communication, a way of reinforcing social norms in an era without mass media. The medieval approach to proportionality forces us to examine our own. Is a long prison sentence served out of sight of the community a more humane or proportional punishment than a short, sharp public shaming? Our system focuses on the deprivation of liberty, measured in years. Theirs often focused on physical pain or public humiliation. Which system is truly more proportional to the harm caused by a crime? And by making punishment a private, hidden affair, have we lost a community-reinforcing message that was a key part of medieval justice? Number 5, why was it a bigger crime to rob someone on a highway than in a field? In medieval England, not all places were created equal in the eyes of the law. Where a crime was committed could be just as important as what the crime was. Certain areas were under a special protection known as the King's Peace. The most important of these were the major roads, the King's highways. To commit a crime on one of these roads was not just an offense against the victim, it was a direct affront to the king himself. It was a breach of the King's Peace, and it carried much harsher penalties. The concept of the King's Peace was another key tool used by the Norman kings to centralize their authority. In the Anglo-Saxon period, peace was a local concept. Each lord or community was responsible for maintaining the peace in their own area. The Norman kings universalized this. They declared that the entire kingdom was under their peace. But they gave special status to certain places and times. The king's own household, his courts, churches, and the major arteries of travel and commerce were under a heightened level of protection. This was a deeply practical measure. The king had a vital interest in ensuring that travel and trade could be conducted safely. The highways were the lifeblood of the kingdom. If merchants and travelers could not move freely without fear of robbery, the economy would suffer, and the king's ability to govern and collect taxes would be undermined. By declaring the highways to be under his special peace and by imposing severe penalties for crimes committed there, the king was using the law as a tool of economic and political policy. He was creating the infrastructure of a unified state. How was this fair? It recognized that some crimes have a wider social impact than others. A simple theft from a house affects one family. A robbery on a major highway affects the entire community by making everyone feel less safe and disrupting the flow of commerce. The law was recognizing a concept we still use today, the idea of public order. The increased punishment was not just for the harm to the individual victim, but for the harm to the public good. This principle was codified in laws like the Statute of Winchester in 1285. This law not only formalized the hue and cry, but also ordered that all highways between market towns should be cleared of bushes and trees for 200 feet on either side. This was to prevent robbers from being able to hide and ambush travelers. The law placed the responsibility for this clearing on the local landowners. It was another example of the law creating a collective responsibility for public safety. The King's Peace was a powerful legal fiction. It transformed a private wrong into a public offense. It was the conceptual foundation for the modern idea that crime is an offense against the state. The legal scholars Pollock and Maitland described the King's Peace as the mainspring of the criminal law. It provided the justification for the king's courts to intervene in local matters and to impose punishments that went beyond simple compensation to the victim. This medieval concept raises questions about how we define crime today. We still have enhanced penalties for crimes committed in certain places, like schools or airports. Are these special peace zones justified? How do we decide which areas of society need extra protection from the law? And by focusing so heavily on the idea of crime as a breach of the state's peace, have we, as the wergild system suggests, marginalized the actual victim in the pursuit of a more abstract public good? Number 4. Could a baker be judged by other bakers? Imagine you bought a piece of silverwork from a goldsmith, but you suspect it's not as pure as he claimed. In the modern world, you might go to a consumer protection agency or sue the goldsmith in a civil court. The case would be decided by a judge who is a legal expert but likely knows very little about the craft of goldsmithing. In a medieval city, you might have another option. You could take your complaint to the Goldsmiths Guild. Your case would be heard and judged by a panel of master goldsmiths, the defendant's peers and competitors. The medieval guilds were one of the most powerful institutions in urban life. They were associations of artisans and merchants who controlled the practice of their craft in a particular town. There were guilds for weavers, masons, bakers, brewers, and virtually every other skilled trade. The guilds had 3 main functions to regulate the training of apprentices, to control the quality of goods, and to provide social support for their members. To achieve these goals, many guilds were granted the right to have their own courts. These guild courts had jurisdiction over matters related to their specific trade. They could settle disputes between guild members, they could punish members who violated the guild's rules. And most importantly, they could enforce quality standards. The Baker's Guild could inspect bread to ensure it was the correct weight and quality. The Weaver's Guild could check cloth to make sure it was properly made. If a member was found to have produced shoddy goods, cheated a customer, or violated the rules, the guild court could impose a punishment, typically a fine. In serious cases, they could even expel the member from the guild, which meant they could no longer practice their trade in that town, an economic death sentence. How is this system fair? It was a system of judgment by true peers. The people making the decisions were experts in the subject matter. A panel of master bakers was in a far better position to judge the quality of a loaf of bread than a royal judge. This system of peer review ensured high standards and protected consumers from fraud and poor quality. It was a form of self-regulation that was both efficient and effective. The guilds also provided a form of localized, accessible justice. A dispute could be resolved quickly and cheaply within the guild without the need for expensive lawyers and a slow-moving royal court system. The historian Sylvia Thrupp, in her study of London merchants, showed how the guilds created a cohesive community with its own set of enforceable norms. The rules of the guild were not just about business, they were about maintaining the honor and reputation of the craft. A member who produced bad work was seen as shaming the entire guild, and the guild had a collective interest in policing its own. Of course, the guilds were also monopolies. They could be protectionist and resistant to innovation. They limited competition and could keep prices high. Their power eventually waned as the economy changed and new forms of industrial production emerged. But their system of internal justice represented a fascinating model of specialized jurisprudence. This model makes us think about our own systems of professional regulation. We still have professional bodies for doctors, lawyers, and engineers that set standards and can discipline their members. Are these bodies as effective as the medieval guilds were? Should industries have more power to regulate themselves, or does that inevitably lead to cartels that serve their own interests rather than the public's? And could a system of specialized peer courts be a more efficient and expert way to resolve technical or commercial disputes than our generalist civil court system? Number 3, how did one king's decree change justice forever? In the year 1166, King Henry II of England was facing a problem. The country was still recovering from a period of civil war and lawlessness known as the Anarchy. Crime was rampant, and the existing legal system was not up to the task of controlling it. Our local courts were often weak or controlled by powerful lords who might protect their own men. Henry needed a way to assert royal authority and create a more effective system for prosecuting serious crimes. His solution was a sweeping set of legal reforms issued at a royal council held at Clarendon Palace. This decree became known as the Assize of Clarendon. The Assize of Clarendon did not create new crimes. Instead, it created a new procedure for finding and prosecuting criminals. It was a masterpiece of administrative law. The core of the Assize was the creation of what we now call a grand jury. It ordered that in every county and in every hundred, a smaller administrative district, 12 lawful men from the 104 from each village had to appear before the king's justices or the local sheriff. They were required to swear an oath to identify and denounce any person in their community who they suspected of being a robber, a murderer, or a thief. This was a radical change. Before, a criminal prosecution usually had to be initiated by a specific victim making an appeal or accusation. This could be dangerous. An accuser might face retaliation, or if they failed to prove their case, they could be punished themselves. The Assize of Clarendon created a new system of public prosecution. The accusation came not from a single, vulnerable individual, but from a jury representing the entire community. It was their civic duty to report criminals. This made it much safer and more effective to bring criminals to justice. Once a person was accused or presented by this jury, they were to be arrested and put on trial. And here, the Assize introduced another key feature. The prescribed method of trial was the ordeal of water. The accused was bound and lowered into a body of water that had been blessed by a priest. If they sank, they were considered innocent and were quickly pulled out. If they floated, they were considered guilty, as the pure water was seen as rejecting them. This seems barbaric to us, but as noted earlier, it was the standard method of divine judgment at the time. The real innovation was the procedure that got you to the trial. How was the Assize of Clarendon fair? It created a standardized, kingdom-wide procedure for criminal justice. It took the prosecution of serious crime out of the hands of private individuals and made it a public, state-run process. This was a crucial step in the development of modern criminal law. By requiring a jury of local men to make the initial accusation, it grounded the system in the knowledge and consent of the community. It was not a system of secret police, it was a system of public denunciation by one's neighbors. The Assize was incredibly effective. It dramatically increased the number of criminal prosecutions and helped to restore order to the kingdom. And as the legal historian Sir Frederick Pollock wrote, it was the first great legislative act of the Angevin period. When the church withdrew its support for trial by ordeal in 1215, the English legal system adapted by using a second, smaller jury, the petit jury, to decide the guilt or innocence of the person accused by the grand jury. And so the procedure set in motion by the Assize of Clarendon in 1166 led directly to the development of the modern system of trial by jury. This powerful decree leaves us with questions about the balance between state power and individual liberty. The Assize created a duty to inform on your neighbors. Is such a system a necessary tool for maintaining public order, or is it an unacceptable intrusion into the life of the community? The grand jury was created as a sword for the state to prosecute crime. Over time, it also came to be seen as a shield, protecting citizens from unfounded prosecution. Yeah, which is its true role, and can a system designed to centralize power in the hands of the government ever be truly fair to the individuals it governs? Number 2, did they assume you were guilty until proven innocent? One of the most sacred principles of modern Western law is the presumption of innocence. The prosecution has the burden of proving guilt beyond a reasonable doubt. The accused does not have to prove their innocence. We tend to think of this as a modern, enlightened concept, far removed from the supposed barbarity of medieval justice. But the roots of this principle are surprisingly deep, and the medieval world was not as universally guilty until proven innocent as we might think. The idea that an accusation is not the same as a conviction is an old one. In Roman law, a maxim attributed to the Emperor Antoninus Pius stated that it was better to let a guilty person go free than to convict an innocent one. This principle was preserved and studied by the canon lawyers of the Catholic Church during the Middle Ages. The Church's legal system, with its sophisticated rules of evidence and procedure, was highly influential. Its canon lawyers argued that a person's good reputation should stand until conclusive proof of guilt was presented. In the English common law, while the procedures were very different, a similar idea began to take hold. The trial by ordeal, strange as it seems, was based on a kind of presumption of innocence. The accused was given a chance to prove their innocence through a divine sign. The system assumed that God would protect the innocent. More concretely, the development of the jury trial after 1215 created a new dynamic. The presenting jury, grand jury, made the accusation, but it was up to the trial jury, petite jury, to be convinced of the person's guilt. This separation of accusation from conviction is a structural precursor to the presumption of innocence. The 13th century legal scholar Henry de Bracton hinted at the principle, but it was more explicitly stated by later medieval jurists. Sir John Fortescue, writing in the 15th century in his work In Praise of the Laws of England, made a powerful argument for the principle. He contrasted the English system, which required a jury of 12 men to be convinced of a person's guilt, with the French system, which he saw as more inquisitorial. He famously wrote that he would rather 20 guilty men should escape death through pity than one innocent man should be condemned. This is one of the clearest early statements of the principle that protecting the innocent is the highest goal of the legal system. How is this developing principle fare? It was a fundamental protection against the abuse of power. To assume a person is guilty simply because they have been accused is to give the accuser and the state enormous power. It forces the defendant to prove a negative, which is often impossible. The presumption of innocence, by contrast, places the burden of proof squarely on the state. It forces the prosecution to build a case based on evidence, not just on suspicion or prejudice. It is the bedrock of a fair trial. The fact that this principle was developing and being articulated during the late Middle Ages challenges our caricature of the period. It shows a legal culture that was wrestling with the same fundamental questions of justice and fairness that we do today. They were building the intellectual and procedural framework for the rights we now take for granted. However, the application of this principle was far from consistent. In trials for treason or heresy, the presumption was often flipped, and the common person without resources or influence might find the presumption of innocence to be a theoretical right rather than a practical reality. This leads to our own uncomfortable questions. Is the presumption of innocence a reality in our modern legal system for everyone, regardless of their race, wealth, or social status? In the age of social media, where an accusation can destroy a person's reputation long before a trial, has the court of public opinion effectively abandoned the presumption of innocence? And how do we balance the need to protect the innocent from wrongful conviction with the need to protect society from the guilty? Number one was a document for barons, really about freedom for everyone. In a meadow at Runnymede in the year 1215, a group of rebellious English barons forced a reluctant King John to affix his seal to a document. This document, later known as Magna Carta or the Great Charter, is often celebrated as the foundation of liberty, democracy, and the rule of law in the English-speaking world. But at the time, it was a practical peace treaty, a list of demands from a powerful elite trying to protect their own interests. Most of the Charter's 63 clauses deal with specific feudal grievances, things like inheritance taxes, the rights of wards, and the location of fish weirs on the Thames. So how did this self-interested document for the 1% become a universal symbol of freedom for everyone? The fairness of Magna Carta lies not in its specific details, but in its core underlying principle: the king is not above the law. Before Magna Carta, the king's power was, in theory, absolute. He was the source of law. The charter established the revolutionary idea that even the sovereign was subject to the rule of law. The king could not simply do as he pleased. He was bound by the customs and laws of the kingdom. This was a fundamental shift in the concept of government. The most famous and enduring clauses of Magna Carta are the ones that express this principle in a more general way. Clause 39 is the most celebrated. No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his peers or by the law of the land. Clause 40 is equally powerful in its simplicity. To no one will we sell, to no one deny or delay right or justice. In 1215, the term free man did not include the majority of the population, who were unfree peasants or serfs. The judgment of his peers was a right for barons to be judged by other barons, not a universal right to trial by jury. But the language was broad enough to be reinterpreted and expanded by later generations. The principles were what mattered. The idea that there must be a legal process, the law of the land, which later became due process of law, before the state can take away a person's liberty or property. The idea that justice should be impartial and accessible to all. Magna Carta was not consistently enforced. It was repudiated by King John almost immediately and reissued and revised multiple times over the following century. But it was never forgotten. It became a powerful symbol. In the 17th century, when Parliament clashed with the Stuart kings, jurists like Sir Edward Coke invoked Magna Carta as an ancient precedent for the liberties of the English people against the tyranny of the monarch. It was used to argue for the principles of habeas corpus, trial by jury, and the supremacy of Parliament. The American colonists, in their struggle with Great Britain, saw themselves as inheritors of the rights guaranteed by Magna Carta. It heavily influenced the U.S. Constitution and the Bill of Rights. The fairness of Magna Carta is therefore a story of evolution. It was a medieval document that contained the seeds of modern constitutionalism. Its true power was not in what it did for the barons in 1215, but in what it came to mean for everyone centuries later. It established a grammar of liberty that could be used to argue for the rights of ever-expanding groups of people. This journey from a feudal contract to a universal symbol of freedom leaves us with the most important questions of all. Do our own legal documents and institutions contain principles whose full meaning we do not yet understand? Are there rights embedded in our laws that future generations will expand in ways we cannot even imagine? And is the story of Magna Carta a reminder that the fight for justice is never about a single victory, but about the long, slow, and ongoing process of turning the promises of the law into a reality for all?